It was in August of 2017 that a 9-judge bench of Supreme Court held privacy to be a fundamental right. Now today, 5 years hence, and after many rounds of deliberations, committees and panels, we finally may have taken the penultimate step towards a data protection regime. Now the Ministry of Electronics and IT today released the draft version for public comments. The third version of the bill is now called the Draft Digital Personal Data Protection Bill of 2022. Now the deadline for public comments is December 17th. Now, as the name suggests, unlike the predecessor, the draft will focus only on personal data. The bill proposed by the parliamentary panel had proposed regulation of both personal as well as non-personal data. Now, personal data has been defined in this draft version as any data that can be used to identify a person in question. Now, examples would include KYC such as Aadhaar being collected by telecom companies, IT returns being collected by banks, your location and address being collected by a food delivery application, bank details being collected by a payment application, so on and so forth. Now, the cornerstone of the bill appears to be consent. Entities collecting data will have to give notice to users prior to collecting information. This notice will have to be in a clear and simple language. Meanwhile, users will have the right to give, manage and withdraw their consent for sharing personal data. Now, one big change has been the doing away of data localization requirement. Earlier version required critical personal data to be stored and processed domestically. This was a big pain point identified by the industry. In the latest version, the centre will notify countries where data can be transferred, stored and processed. Now, the earlier Raftar also gave a blanket exemption from compliance to the government. While the blanket exemption has been dispensed with, the centre will still have the power to grant exemption in cases of national security and public order. Now, the Data Protection Authority under the earlier version is now called the Data Protection Board. The earlier version provided for penalties of up to 4% of annual turnover. Now, the penalties that can be slapped by the board are limited to a maximum of 500 crore rupees. Now, the strength and the composition of the board will be prescribed by the centre. The board shall also have the powers to summon persons and inspect computers. Board can issue binding orders and they will carry the same weight as an order of a civil court. Now, under the draft bill, entities collecting data shall be responsible for ensuring correctness of information. They will also be required to take reasonable measures to ensure data security. In case of a breach, these entities will have to disclose to the board as well as to the user. Now, for individuals like us, we can seek clarity from a company in case our data is being processed or collected. We have the right to seek deletion of data once the purpose is satisfied. We also have the right to access to a grievance redressal mechanism. Now, the government had withdrawn the earlier bill to make the new bill a simple and innovation-friendly one. Now, has the government realized its goal? Stakeholders will be subjecting this draft version to tight scrutiny.